candid advice during meetings would then be divulged, people would start withholding frank and candid advice during meetings. This was discussed in the exemptions that we proposed to introduce. And again, as Nepo and Erin pointed out, the question is that there is existing case law on this, but that it is primarily focused on the president. It cannot be extended so vastly so that a municipal council or subordinate official somewhere will start invoking it, because that is not the intent of case law, nor is it what is necessary in government. The next concern would be about communications privileges and how these should be protected. And again, these were introduced, proposed to be introduced based on the following language that you see there. And again, this has been whittled down to make sure that this is explicitly for the chief executive only and cannot be used or abused by other officials. This was another concern that the president raised, where he was saying that in the case of investments, where investments may be politically sensitive in other countries, and therefore it would not be politic for the government to immediately reveal it, lest it cause a concern overseas. And he was specific in the case, for example, of BPOs, where if there's an ongoing negotiation to establish a BPO in the Philippines, and a premature disclosure of this would cause, let's say, a political firestorm in the United States where they're sensitive to the loss of jobs, he felt that there should be some sort of protection for this. And this was clarified in the exceptions for that. Now, the other was because there are ongoing legislation being discussed, such as the data privacy law, and this was less controversial in that the Freedom of Information Act should be in harmony with other legislation, such as the data privacy law, to protect personal privacy and data. Now, these were other things that we proposed, the inclusion of implementing rules and regulations. This is particularly important for the bureaucracy. The concerns of the bureaucracy were quite clear. Of course, their attitude is whatever is policy will have to be implemented, but they're really concerned about the bureaucratic side of things. Who is supposed to have authority over what? Who will be responsible for what happens when there are many requests? In particular, what has been mentioned quite often is the experience in Australia, where if you talk to Australian officials, they have been deluged by FOI requests, and it has put quite a strain just in terms of responsibilities and time management for the bureaucracy in Australia. So this was something the bureaucracy felt very strongly about. Is that if, for example, an official were to decline to approve a document, or the decision of an official was questioned, would then everyone end up being hailed to court and being deluged by court cases? And the question was, if the objective is to secure the release of information, then there should be a body that can act as an arbiter in these things, and the idea is an information commission. Upon the feedback of the proponents and the sponsors, there have been clarifications made that this will be independent and on par with other constitutional commissions, and no longer under the Office of the President.